Okay, we are on the record, and this is Dart Container of Michigan LLC et al. Versus Stephen Mills et al., docket number 20-333 CB. This is the time set for hearing on John Hughes and J.R. Hughes Management's motion for summary disposition. And I'll have you first all state your appearances for the record. Understanding it's a little difficult via Zoom, so I'll call on you by client so you'll know what order and you're not speaking over each other. So first, appearances for the plaintiff, please.
I'm sorry, Your Honor. Scott Mandel, representing plaintiffs, along with Brandon Shoemaker. Also attending the hearing are the General Counsel, Frank Leisman, and Assistant General Counsel, Jeff Gibbs.
All right, thank you. And then appearances for the Mills defendants, Stephen Mills and Mills Real Estate Consulting. We don't have any? It's not their motion, but I just wanted to check. Okay, and then for John Hughes and J.R. Hughes Management.
Good afternoon, Your Honor. Jennifer Gross appearing on behalf of John Robert Hughes and J.R. Hughes Management, and we also have John Hughes on the line attending as well.
That's fine. Okay, and this is your motion, Ms. Gross. So whenever you're ready, you can go ahead.
Thank you, Your Honor. Just as some background, obviously, I'm sure you've read the complaint. There are numerous allegations against mostly Mr. Mills and his company, and the allegations essentially allege a scheme by which somehow my client conspired with Mr. Mills to pay kickbacks to Mr. Mills for some reason that isn't entirely clear from the complaint, for commercial real estate services that were provided to the plaintiffs, primarily by another entity that isn't a party in this litigation, which is Newmark Real Estate of Michigan LLC. Mr. Hughes was a broker working under contract with Newmark. So the entirety of the claims that plaintiffs have stated here rely on Mr. Hughes engaging in some kind of, or I should say the claims against Mr. Hughes rely on him knowingly engaging in some kind of kickback scheme, and having full knowledge on the legal relationship between Mr. Mills and Dart et al., the plaintiffs. Because the complaint falls far short of the legal allegations, even if taken as true, to substantiate the claims against my client, we're asking for summary disposition. So I'll start with our argument with regard to counts 3 and 4, which are aiding and abetting fiduciary duty breaches. Aiding and abetting breaches of fiduciary duty by Mr. Mills. There's a distinction with those two counts between his officerial capacity and non-officer capacity. So, but regardless, the claim is that Mr. Hughes knowingly aided and abetted Mr. Mills's breach of fiduciary duty against the plaintiffs. And as set forth in our motion, the law in that area is very clear. In order to make out a claim for aiding and abetting a breach of fiduciary duty, the plaintiffs had to plead sufficient allegations when taken as true to establish that Mr. Hughes had knowledge of the wrong, in this case, the breach of fiduciary duty, and took material action to advance it. Here, the allegations, even if taken as true, don't establish that Mr. Hughes knew that anything that Mills was doing was a breach of fiduciary duty. So that claim, both of those claims, counts 3 and 4, which are essentially identical, must fail as a matter of law. With regard to the count, I apologize. I think that was I'm missing one here. I think there's another claim count. I think it's count 4, breach of fiduciary duty. That one alleges a breach of fiduciary duty by Mr. Hughes against or I'm sorry, a breach of fiduciary duty by Mr. Hughes of a fiduciary duty that was owed by him to plaintiffs in this case. And there are a couple elements of fiduciary duty that Michigan law requires to be pled satisfactorily that aren't met here. First, plaintiffs have failed to allege the existence of a fiduciary duty directly with Mr. Hughes. Their relationship, upon information and belief, was with Newmark, who then contracted out to Mr. Hughes to provide these services. So they haven't established a link, so to speak, in the fiduciary duty chain binding Mr. Hughes to fiduciary duty to the plaintiffs. And Newmark isn't a party in this litigation, which is also an interesting point. In addition, there's a problem here with damages. The allegations with regard to damages are flaws of all the claims against Mr. Hughes. Essentially, they are claiming that they were damaged by Mr. Hughes's alleged payment of a commission to Mills out of these commissions he received from Newmark for these commercial real estate transactions. They aren't claiming that they did not receive fair market value. They're not seemingly trying to undo the transactions, but yet the amount of the damages claimed appears to far exceed any amount that they claim was ever paid to Mr. Hughes for commissions. So they've failed to establish that there are any damages here, even though they're asking for, I think, $9 million or $7 million, something like that, which isn't clearly explained in the complaint, but my assumption is it has to do with the total amount of compensation that was paid for all of these services rendered by Newmark, in which Mr. Hughes was involved. And so for that reason, because they failed to establish sufficient allegations of the existence of a fiduciary duty from Mr. Hughes to the plaintiffs, and because of the lack of damages, the breach of fiduciary duty claim must also fail. Turning to count 8, which alleges a civil violation of MCL 750.125. This is a penal statute. It's a criminal statute, anti-kickback statute. The general rule in Michigan is well established that you can't make out a civil wrong or a civil claim for breach of a penal statute unless the statute itself contains a clear right for a civil plaintiff to recover. Here, there is no such clear right, and to forestall an argument by the plaintiffs, in their response, they cited to a very narrow exception, a case that dealt with the Michigan Builders Trust Fund Act. And as set forth in my reply, that was a very narrow exception where the statute itself created a beneficial interest on behalf of a party who was wronged by breach of that statute. It specifically created a trust for funds that were paid to various parties in building transactions, and also specifically made recipients of those funds trustees, such that the court thought the intent of the legislature was to create a beneficial interest or a beneficial trust for the individuals who were wronged by breaches of that statute. That's a very narrow exception, but the general rule is unless there's a specific right established in the statute, you can't recover under a civil claim for a breach of a criminal law. And plaintiffs haven't cited any authority to support specifically that the anti-kickback statute that they have in their complaint would actually, that has been interpreted to ever have a beneficial interest such that a civil plaintiff could recover. In addition, count 10, which is a breach of contract claim against Mr. Hughes, must fail. They failed to allege the existence of a contract. Even their response essentially reiterates the one paragraph in their complaint that says, in essence, that the transactions that Mr. Hughes provided services on constituted a contract between him and plaintiffs. But they, I believe, and they reference this in their complaint, have contracts directly with Newmark, who engaged Mr. Hughes to provide these services. So there isn't a direct contractual link between Mr. Hughes and the plaintiffs in this case, and they haven't alleged any or attached any contracts or otherwise raise sufficient factual allegations then, even if taken as true, that would establish a contractual relationship there. So their breach of contract claim is fatally flawed. In addition, the remainder of the claims deal with fraud. There's a fraudulent misrepresentation claim and a silent fraud claim. Both of those claims require sufficient facts to establish a material misrepresentation, which is one that would have, had the plaintiffs known it, changed the outcome of their decision making. Essentially, they'd have to allege that, but for that misrepresentation, they would not have entered into the transactions. And while they claim that in their response, the complaint doesn't support that in allegations. There isn't an allegation that they wouldn't have entered into these contractual arrangements. In fact, they haven't sued Newmark, who is the entity that they entered into contracts with. They have taken the benefit of those bargains. They have, seemingly have no issue with the underlying transaction. So it seems that they couldn't allege that that was a material misrepresentation because it clearly didn't affect their desire to maintain the underlying contractual deals, because they haven't tried to undo those. In addition, they have to show, or they have to allege, that Mr. Hughes intended that they rely on his misrepresentation, or his alleged misrepresentation, which was that he didn't tell plaintiffs allegedly that he was paying commissions to Mr. Mills on these transactions, and they have failed to allege that this was intentional on Mr. Hughes's part. It's undisputable that Newmark would not have disclosed every single payment made out of commissions paid to them for the services that were rendered in these cases on these contracts. So, they didn't tell the plaintiffs, every single individual, that they paid for services related to those services that they provided. So it doesn't follow that the mere fact that this wasn't disclosed, even if true, constitutes an intentional misrepresentation on which they intended the plaintiffs to rely. And with regard to silent fraud, there's those same issues apply, but then there's also the failure of allegation of a legal duty to disclose. Silent fraud requires there be a legal duty to disclose the material fact that's being alleged. And in this case, plaintiffs have not alleged that, or satisfactorily alleged that Hughes or J.R. Hughes had a legal duty to disclose the fact that payments were allegedly being made to Mills from commission paid to Hughes by Newmark. So there isn't a showing anywhere of a legal duty to disclose that fact. Again, Newmark undoubtedly paid other entities out of the commissions that they were paid, and those entities were not disclosed to the plaintiffs, and they don't allege that there was an issue there. So they're failing to establish that legal duty, and without a legal duty, that claim must fail as well. And finally, count 14 is a civil conspiracy claim, and as Your Honor no doubt is aware, there has to be an underlying actionable tort in order to establish a civil conspiracy claim. In this case, because the other claims which sound in tort in their complaint failed, then civil conspiracy also must fail. So for those reasons, we'd ask that all of the claims against Mr. Hughes and J.R. Hughes Management Company be dismissed as a matter of law.
All right, thank you. And either Mr. Mandel or Mr. Shoemaker, whoever's arguing the response.
Thank you, Your Honor. Your Honor, I'm well familiar with how thoroughly this court prepares for hearings, all hearings, especially hearings of this nature. And I will try to limit my remarks in light of that. If I miss something or the court has questions, I would invite the court to let me know that, and I will try to respond to those questions. As the court reviews this motion, I don't believe it's lost on any of us that as it was filed, the defense alleged and argued both C8 and C10. As we pointed out in our response, there'd be no bases whatsoever for a C10. They did not attach anything. And I heard a very fine argument, but I did not hear any reference whatsoever to C10. So I'm assuming I'm only to respond to the C8 portion of this motion for purposes of oral argument. And with that understanding, as counsel herself acknowledged, this court is to take every allegation in the complaint as true. And as counsel was making arguments, I heard her make representations about certain things being indisputable, about who Newmark disclosed to or would have disclosed, where money went. There's nothing of that nature anywhere in this complaint. There's nothing indisputable about any of that. And it's not appropriate for this court to look at that or even consider that type of an argument in this context of a C8 motion. It's just to look at the pleadings itself. And when we look at what has been alleged and what is being argued, we can go through that. Our brief does it in considerable detail. I'm just going to highlight at least what we believe to be the key points as the court is making its decision here. Starting with the argument about the counts dealing with aiding and abetting Mr. Mills' breach of fiduciary duty. I believe that's actually counts 3 and 5. The argument that I'm understanding counsel to make is that we did not properly allege knowledge. To start with that, as far as the standard, I submit that we really should go back and look at the court rules and MCR 2.112 B2 talks about that malice, intent, knowledge, and other conditions of mind may be alleged generally. So the type of detail counsel would like to see, well, perhaps to prove this down the road, this would be an appropriate argument if it were a C10 at the end of discovery and we came forward with nothing more, but that's not the context this court is reviewing this motion. So did we at least meet that standard that we generally alleged it? And I submit the answer to that is yes. And if the court looks at paragraph 119 of the complaint, we allege there that, I'm going to talk about both entities, Hughes knew of Mills' breaches of fiduciary duty. Counsel's arguing, well, we didn't allege that Hughes knew of the specific duties that he had vis-a-vis relationship with his employer, Dart. Well, this, again, at least in general terms, this alleges that he did know about that Steve Mills had breached his fiduciary duties, aided and abetted him with that. And then we go on in far more detail to set forth more specific allegations about Mr. Hughes on this kickback scheme, the amounts paid, the period of time that was paid, that he knew that he wouldn't continue on with the business relationship as far as materiality was concerned, and that this was a violation of what Mr. Mills was to do with his own employer. And we set those out in detail in our brief, and we quoted verbatim those allegations. So I respectfully submit that there has been a sufficient pleading with respect to that count. On the breach of fiduciary duty claim, counsel argues that we did not allege that there was a fiduciary duty owed. And again, the complaint itself makes specific allegations about that, sets out the acts themselves, the Brokers Act, MCL 339.2512 D2 provides that a licensed broker, and again, it's alleged in the complaint that Mr. Hughes and the company, they were licensed real estate brokers in Michigan, that they had the duty of loyalty and confidentiality among other duties. So again, that's alleged in our complaint. Paragraphs 12 and 13 make specific allegations about the company and Mr. Hughes being licensed. And then paragraphs 27 to 30 and 146 to 147 specifically allege that they're operating as real estate brokers. The second part of that argument is that we did not allege damages. And again, looking at the face of the complaint, they're set forth. Counsel may not like these, and whether we are able to recover them ultimately at trial is not the question. Is it alleged? Paragraph 153 alleges $7.3 million in damages for restitution the commission's paid, and there is authority cited in our brief that we can, at least we have the possibility, the right to ask for, to seek, recover restitution of monies paid. In addition, Other damages, general damages, do not need to be pled with specificity. It's MCR 2.112, subpart I. And in the complaint, paragraph 66 and 67, we do make allegations of the general damages sustained by DART, including that they would not have continued on with this relationship had they known about this kickback scheme, which is at least specifically alleged was not disclosed to DART and was required to be disclosed under these acts. The next argument we understand counsel be making involves what we're describing and stating to be the anti-kickback statute. That's MCL 750.125. And first, counsel is correct that there is not a case out there that has wrestled with this issue of whether or not there is a private cause of action. So I cannot point to the court that a case come out specifically recognizing that under this particular statute, there is a private cause of action, nor can counsel point to any case that says there is not. This is a matter, at least under this particular statute, of apparently first impression. It simply has not wound its way up to the appellate courts for either of us citing the case law. The argument that was originally made in the brief in support of this motion was there is no such thing as any sort of private cause of action under a penal statute. And I understand they're no longer making that argument. We pointed out that the penal case recognizes there can be a private cause of action, and we've cited that case. Counsel suggesting, well, that's an extraordinarily limited exception. It would only apply when there is a beneficial interest, and indeed the opponent uses the word beneficial interest. Counsel's arguing what that means is it only applies when there's a trust. Well, there's no authority anywhere suggesting beneficial interest only means a trust. DePino cites to the case of BF Parnell Company, which is 377 Mich 552 and 556, page 556 of that decision talks about beneficial means for the benefit of another. And again, when we look at is this for the benefit of another, that's what we're talking about with the anti-kickback statute. And the employer has the benefit of knowing that their employee can't be induced into a scheme of this nature. Again, we recognize we have to prove this to recover, but that's not the test for purpose of this motion. It's have we alleged it. And we don't have to allege that there was a specific trust, nor is there any such requirement. Gardner versus Wood sets out the factors for when a private cause of action of this nature can be found to exist or held to exist. And we respectfully submit that those factors do attach and they apply here. Now, whether we establish all of this later is something to be looked at perhaps at the end of discovery with another motion under C10 or at trial. But has it been pled? Again, we respectfully submit the elements have been pled and that we do fall within these cases recognizing that cause of action. Now, if the court is going to confine its analysis to looking at the specific statute itself, I respectfully disagree with counsel's argument that, well, that there's nothing in the statute suggesting private cause of action. We point out in our brief that this particular, the anti-kickback statute we're referring to, MCL 750.125, subsections 4 and 5, both reference that this allows for a proceeding and a prosecution. Prosecution would be, of course, criminal. Proceeding recognizes that the act itself applies in something broader than a prosecution. So we respectfully submit that that also supports our position that there is a private cause of action that could exist under that statute. The next argument involves breach of contract as it relates to Hughes. And there, again, as has been alleged, paragraph 31 of the complaint alleges that there was a direct connection contract existence between Mr. Hughes and the plaintiffs in this case. That's the allegation. And counsel says, well, we didn't attach these contracts. That's also accurate, but the complaint makes a specific allegation about that, which is not refuted anywhere, including in this motion. We said that the other side has copies of the relevant and material documents on the contract, and that is why they're not attached. In this motion, in their brief, they don't say, well, gee, we need those, to attach them. That's why they're not attached. We made the specific allegation there was a contract for purpose of a C8 motion. It has been pled. And we also are alleging that these other transactions were with Hughes and Newmark, not just Newmark. That's the allegation. So I know that counsel's made an argument in her brief that Hughes was an independent contractor for Newmark. That's nowhere alleged on the face of the complaint. It's not a C10 motion. Nothing's been provided to the court to support that assertion. The allegations of the complaint are Newmark and Hughes. So it has been alleged concerning the breach of contract. On fraud and the allegations of fraud itself, again, the argument here effectively is that this knowledge has not been alleged. Again, MCR 2.112 subpart B2 talks about when you're dealing with knowledge, it can be pled generally. I've already referenced that and covered that. And the materiality aspect of that is set forth in paragraph 78 through 93 of the complaint. And we talk about that in some detail in the brief, and we did go into that in detail. The silent fraud, again, we specifically alleged there was this duty to disclose that's set forth in the Brokers Act itself. There is an obligation to make a disclosure of this nature. It is alleged. It was not done. And then the conspiracy count assumes the court grants this motion on all of the underlying individual tort claims. We've already argued those, why those exist, and that's why we respectfully submit that portion of the motion should be denied. So we are asking this court to deny this motion in full. If the court is inclined to grant any portion of the motion, we do ask for the opportunity to amend the complaint. Thank you.
Thank you. Ms. Gross, do you want rebuttal time?
Sorry, Your Honor, I was unmute myself. Just briefly, if I may, I appreciate it. Just briefly with regard to the anti-kickback statute, I just want to clarify that as stated in the case that was cited in the response by plaintiffs, which is the BF Barnell case, 377 Mich 552 at 555. It references when a statute provides a beneficial right but no civil remedy for its occurrence, the common law provides a remedy. And that was the basis in the court reading into the statute to establish that beneficial right. And in that case, it was very clearly stated there was a trust. These funds were in trust, and the recipients of the funds were a trustee. While I was not arguing, and I don't think it may not be necessary to establish that there's a trust, there has to be at least some kind of beneficial right provided in the statute. And as it stands, the count with regard to the anti-kickback statute does not contain allegations as to how there is a beneficial right under the statute for recovery. So in that case, it's clear the statute itself does not on its face provide a right of recovery. And so it's on, the onus is on the plaintiffs to establish facts which support the right of recovery under that statute, which wouldn't otherwise provide for it under Michigan law. So the fact that that's their burden, and they have failed to meet it by alleging facts which would establish some sort of beneficial right on the part of the plaintiffs against my clients. And then with regard to the contract claim against Mr. Hughes and J.R. Hughes, which is count 11, it looks like, the counsel for the plaintiffs mentions that we have contracts in our possession, or that they don't have copies of contracts, but when in fact they allege, and their only allegation with regard to the existence of a contract is paragraph 195, which says Dart, Mr. Hughes, and J.R. Hughes as a de facto party executed 60 real estate transactions relating to Dart owned real estate, which constitute valid enforceable contracts. So they haven't alleged that there are contracts existing directly between Hughes and J.R. Hughes. They've alleged most that they have real estate transactions that involved Hughes and Mr. J.R. Hughes. So I wanted to clarify that while there's some confusion between what is actually in the complaint and what counsel was representing with regard to the existence of contracts. I know there is a reference to contracts in the complaint, and that's saying that they're not attached. But that reference relates to contracts between Newmark and plaintiffs. So I just wanted to clarify that. And with regard to the remainder of the allegations and the claims, defendants will rely on the extensive discussion in their original motion and reply brief and support, and ask that this court dismiss the complaint as to Mr. Hughes and J.R. Hughes in full. Thank you, Your Honor.
Thank you. Well, as has been stated, this is brought by John Hughes and J.R. Hughes Management. Just for ease of reference, I'm going to just call them the Hughes defendants bringing this motion. And it was brought under C8 and C10, but as counsel has correctly noted, it had no evidentiary support that would be required for a C10 motion. So, and that's not surprising because it was brought as a first responsive pleading. So it really is merely a C8 motion. And a C8 motion requires the court to take all well-pled allegations in the complaint as true and assess whether there's a legal basis or whether they state a legal claim. So with that as the beginning of this, I will go as counsel has, count by count. So the first portion of the Hughes defendant's motion pertains to counts 3 and 5, aiding and abetting breach of a fiduciary duty. And the defendants claim, first of all, that the complaint fails to plead knowledge, and that only does it in a summary sense with no supporting facts. However, the plaintiffs correctly note that MCR 2.112 parent B provides that knowledge may be pleaded generally. So the specificity that the Hughes defendants are complaining about is not required. But even aside from that, the complaint does allege underlying facts that would support knowledge. So I do not think the complaint fails in the way that the Hughes defendants claim with respect to knowledge. They also say that the complaint fails to allege that Hughes knew the actions to violate the agreement between Mills and plaintiff. And having read the complaint in its entirety, I am concluding that that's not necessary because the fiduciary duty, it doesn't seem to be dependent on an agreement. It's dependent on the Broker Act and the common law. So there is no requirement that there be allegations that Hughes knew actions violated any agreement between Mills and the plaintiff. The Hughes defendants also address count 6, breach of fiduciary duty, and say that it fails to allege a relationship giving rise to a fiduciary duty. But again, the fiduciary duty claims are based on the Broker Act. The complaint alleges that Hughes was acting as the plaintiff's real estate broker. I have to take that well-pled allegation as true. And that's not a leap, since Hughes has acknowledged that he performed services on behalf of the plaintiff. So that is not a deficiency in the complaint. The defendants also, with respect to count 6, say that damages have not been pled and that there are none because the plaintiff didn't pay any greater amount of commission than they otherwise would have, and that the plaintiff received the fair market value of the services rendered. Whether there are damages or not is a matter of proof, and it's not for a C8 motion. But I would also say that the complaint does allege that the payments were based on something other than the fair market value of the services rendered. The complaint alleges that the payments were basically meant to enrich Hughes, and that's covered in the complaint, paragraphs 63 through 67. That takes us to count 8, the anti-kickback statute, which of course is in the penal code. And although in the briefing, the Hughes defendants say that there is no civil action for violation of a penal statute, it would appear that in argument they've conceded there may be, but that they're arguing it's a very, very narrow and not applicable here exception. That's good because the only authority they cited in the brief was the Gould case, and the Gould case had no applicability to the issue here. So assuming that they have abandoned that, I will go on to address what the plaintiff puts forth, which is the Gardner case. And the Gardner case is directly applicable. It holds that there may be civil action for violation of a penal statute, and it gives us a test to apply, and if the matter meets the requirements of the test, the court said that a civil remedy may be afforded through an existing tort action or a new cause of action analogous to an existing tort action. And if there is no common law tort action that's analogous, that fits, then a new tort may be created for that purpose. So the test basically looks at you look at the penal statute and you look at who it's intended to protect, what kind of an interest it's intended to protect, the kind of harm it protects against, and the interest against the particular hazard from which the harm results. So the analysis was pretty straightforward in the Gardner case because the civil action really was unrelated to the harm and the individuals that the criminal statute was directed at. That is not the case here. I think they are just directly analogous. The classes of harm and individuals are indistinguishable. The anti-kickback statute is protective of employers or principals. What's being sought here would protect an employer or principal. The anti-kickback statute is protecting, basically as I read it, financial conflicts of interest by employees or agents. And here we have an action directed towards financial conflicts of interest by employees or agents. And the kickback statute protects the employer or the principal's monetary interests. Here we have an action that's directed at protective measures of the employer or the principal's monetary interests. It's directly analogous, and if you compare it to the situation in Gardner, it's easy to see how Gardner was not analogous at all, didn't protect the same interests at all. Very, very much unlike the case that we have here. We also have to look at the penal statute and ask whether there's anything in it that precludes a civil action. And I would say definitely there's nothing in it that precludes a civil action. And as the plaintiff pointed out, there's even language in it that would suggest that there could be a civil action because it specifically refers to, quote, proceeding or prosecution. So that seems to contemplate that there could be a civil action. But nevertheless, it meets the requirements directly of the Gardner case. And I think it's legally valid and completely supportable to infer a private cause of action on these allegations under the anti-kickback statute. So I have to reject that argument by the Hughes defendants as well, which takes us to count 11, breach of contract. The Hughes defendants say that the contract was with Newmark and that Hughes was not a party. The complaint alleges that the contracts were with Newmark, Hughes, and J.R. Hughes. So if it's alleged in the complaint, it's a well-pled allegation, I take it as true, and it does not fail for that reason. Count 12 is the fraud count, and the defendants, the Hughes defendants, say that the complaint fails to allege 3 matters with respect to fraud. Materiality of the misrepresentation is one. Hughes' intention that the plaintiff would rely on it is the second one. And that injury was suffered as a result is the third one. Well, with respect to materiality, I believe that it is covered in paragraphs 48, 49, and 50. With respect to the intent to rely on it, it is covered in paragraphs 78 through 97. And with respect to damages, it's covered in the allegations of the commissions that were paid and to Hughes, and it's alleged there were overpayments as a result to Mills. So I disagree that the complaint fails to allege those required elements of fraud. With respect to count 13, silent fraud, again, the plaintiffs claim that, the Hughes defendants claim that there are insufficient or conclusory allegations of a legal duty to disclose. And the second complaint they have is insufficient allegations of materiality. And the third is that there are no damages. And again, I would state the duty I've already discussed is in the law, and it is alleged in the complaint in paragraphs 214 and 215. And that is that real estate brokers have a duty to disclose material facts to their principal. And then the 2 other complaints that the Hughes defendants have, materiality and damages, I've already addressed with respect to other claims, but they are also sufficiently alleged in the complaint. And then finally, count 14, civil conspiracy, and that's just an argument that there's no separate actionable tort. It assumes that I am dismissing all the tort claims. I'm not. So that argument fails as well. So for all of those reasons, I am denying the Hughes defendants' motion under C8. And Mr. Mandel, if you want to submit an order for the reasons stated on the record, if that's...
I'll be happy to do that, Your Honor, certainly.
All right, thank you.
Thank you, Your Honor.
Thank you. That'll conclude our hearing.
Thank you.